So, howdy everyone, I'm David Glazer.
Hi, and I'm Steve Helland.
So, I'm not really here for long. I'm just going to do a quick introduction of Steve and do our announcements, and then Steve will take it away. So, the handful of announcements, we're trying to get more active on Twitter. I'm on there. I have a total of, I believe, 1 follower. But Frederickson Health Law on Twitter, Briar Andreessen, who is perhaps the funniest person I've ever met, is running our Twitter page. And you can actually check out Frederickson Health Lawyers and their dogs right now. But we'll also have substantive stuff. May 15th is our next webinar. Kevin Rich, our colleague, is going to be talking about marijuana and everything that those of you in the healthcare industry need to know about patients who may be requesting a prescription or who may be using marijuana, just all of the marijuana healthcare related issues. We will soon have a webinar on the provider-based guidance that we're expecting from CMS any day, but the any day keeps moving out, and having long since learned that lesson, we won't schedule it until we see the guidance. But we may even have a special webinar. We'll figure it out when that guidance comes out. Only other announcement, if the sound goes south, you can always dial in to the number that Robert is putting out. So we're super lucky to have Steve Helland with us today to talk about website accessibility. And I won't spend much time talking about Steve except to say, A, if you've got an EHR contract, one of the things I've learned is I know nothing about those things. And Steve, Ann Ladd, and Briar Andreessen are 3 people here who have taught me a boatload of stuff, way more than I can know. Steve is really good at EHR contracts. So if you're ever looking at one of those, think of Steve. And also on this ADA website stuff, he's helped literally dozens, I think he's over 50 perhaps, clients with their ADA website stuff. So this isn't his wheelhouse, and Steve, take it away.
David, thank you for that. I'll say that the check or the bottle of wine is in the mail for that endorsement. That was very thoughtful. And thank you for this audience. It's great to be here. This is a really nice group that David and the Health Law team have curated over time, so it's fun to be part of this. All right, so I am a little bit of a fast talker. If I start talking too fast, please just, you can send the message through the message function, and Robert will wave to me and say, Steve, take a breath, slow it down. Here's what we're talking about. What we're talking about is the evolution of the Americans with Disabilities Act and disability or anti-discrimination law to shift from applying to purely physical spaces, right, so that there would be ramps next to the stairs so that a person using a wheelchair could enter a building, or a handicapped disabled parking space, or any one of the other things that we're used to in the physical world. We're now seeing that law evolve and being applied to digital or virtual or website spaces. And over the past few years, there has been an explosion of litigation and disputes in this area like I have never seen before in my 22-year career as an attorney. And interestingly, right, this explosion of litigation is not the result of a new law. In fact, to the contrary. It is sort of like, as David was mentioning with some other regulations that have not landed yet. One of the recurring themes you'll see here is how regulations and clarification promised by the Department of Justice repeatedly, but that have failed to arrive and are now not expected to arrive anymore, have actually stirred confusion into the environment. So, with that, let's go. We will end on time. I'm also not going to read to you every bullet point on every slide. You've got the slides. Here's our agenda. My goal is to be practical, educational, and hopefully interesting, although you will be the judge of that. We have in our audience, I know, since I get to see who's pre-registered, we have some folks that I know are extremely knowledgeable in this area and have perhaps been through a dispute or a matter. And of course, I'm not going to name you, but I'll say I know that there are some folks that are very well versed in this issue, and then there are other folks to whom this is probably a brand new issue. For those of you to whom this issue is brand new, actually, because there have been so many lawsuits and so many cases, it's entirely possible that your organization has been sued and you just didn't know it because the case was settled or stayed entirely within the legal department if you're not in legal. So the coverage of litigation is extremely broad. I'll also say, by way of my disclaimers, that this talk is for informational purposes only, and that although it's very flattering for me when plaintiffs or people on the other side, because I'm defense only, or I'm website owner-operator and app owner-operator representation only, when I'm quoted back to myself in a dispute or in litigation, but I'll just say this is a general presentation, and my comments may or may not apply to any specific case. And for those of you who are extremely experienced in this area, feel free to, again, text Robert with either questions or agreements or disagreements, because that will make this more lively. All right, so how did we get to where we are today with this explosion of litigation? Let's take a little step backwards to figure out how we got here. If we go back to 2006, the National Federation of the Blind filed lawsuit in the Federal District in California against Target for their website, target.com. And that case settled in 2008 for about $6 million plus several million more in attorney's fees. And I was all proud of myself at that time because I wrote a short little news blurb about it, and I thought, you know what, this is going to be the next big thing. But it wasn't. Actually, starting from 2008 and beyond, it was very, very quiet for a few years. There was a little bit of enforcement action by the Department of Justice, and they brought some actions and settled them, but it was pretty quiet, and there was almost no private litigation. And the reason why there was almost no private litigation is that the Department of Justice had promised that in around 2010 they would issue regulations saying what accessibility looks like in digital spaces on the internet. Because as they do in some physical spaces, right? The Department of Justice, there are regs that talk about, to be handicap accessible, a hallway has to be so many inches wide, or a sink has to be so many inches tall, etc. So folks on both sides, both plaintiffs and website owner operators were waiting. I was waiting for these regs to come out. In 2010 came and went. Department of Justice said, no, just kidding. We're not going to do it in 2010. We're going to really do it in maybe 2012, 2013. 2012, 2013 came along. Again, nothing happened. Department of Justice kicked the can down the road further, said, no, it'll happen further on. 2015, that's what we really mean. Well, the fall of 2015 came and went. Department of Justice said they still weren't going to be issuing regulations yet. They hope to do it at some point in the next couple of years. At that point, a couple of plaintiff firms decided they had had enough waiting, that they were going to begin litigation and just sue under the law itself without there being regulations. And that's when actually there's a firm in Pennsylvania, Carlson Lynch, was the first one that really began doing kind of a multiple or a series of pieces of litigation, at least as far as I'm aware. They had previously been involved in bringing lawsuits against banks and other financial institutions for non-accessible ATM cash machines. And so this was kind of the next evolution, since they were already knowledgeable and experienced in that space. That's when litigation began to take off. Litigation now is huge. So I show this particularly to my business colleagues that don't always believe me what I say. I quote the Wall Street Journal to them, and that's persuasive, right? Lawsuits surge over websites access for the blind. That's a news story headline from 2019. And what happened was, like I said, the floodgates began to open in 2015. With dozens or scores of federal lawsuits. In 2016, we saw a couple hundred. In 2017, it doubled again. I think by some estimates in 2018, we had a couple thousand, like over 2,000 federal website accessibility cases. And those are the ones that we know about, right? On the state level, there could be as many or more, but it's really hard to track. And of course, none of this gets at private settlements. I read one more headline, just kind of re-emphasizing what I just said. And there are thousands, and so I'll show you this slide with. I'm not trying to pick on anyone here, right? I could have picked any one of thousands of other organizations, probably, frankly, tens of thousands at this point if you count demand letters. So I showed this slide for those of you to whom you're like, is this really a thing? Yes, it's really a thing. And the lawsuits are prevalent. They do tend to settle quickly in most cases, and that might be why you might not have heard of them. And of course, folks who get sued don't go out and brag about it in most cases. It impacts large and small businesses. It impacts businesses in all parts of the country. Although I happen to be in Minneapolis, my clients have been sued. They're usually sued in the home state of the blind or disabled plaintiff. And so the bulk of the lawsuits are in Pennsylvania. New York is number one. Florida or California might be kind of tied for number two over time. It depends upon the year. Texas, there's a few. Again, Pennsylvania. There's been and then there's a smattering in other states. But just because you're located in a particular state does not necessarily give you comfort, because again, the web and apps tend to be viewable, or you can access them online from anywhere, and so you might get sued in a different place. All right, so this is a headline that you never like to see if you're Epic, right? Blind advocacy group sues Epic again, and that's again from March 2019. As we try in the past, some of the heaviest concentration of litigation was against online retailers and restaurants. But we're seeing now an increase in the level of concentration of lawsuits brought against healthcare or health-related entities, and this headline here from Becker's is just one example of that. Also, just like the Target lawsuit from 2006 was brought by the National Federation of the Blind, and that was in a sense like a precursor or an omen of things to come in the future, because it wasn't just any ordinary plaintiff, it was the National Federation of the Blind that tends to bring issue-based litigation. Here again, it was the National Federation of the Blind reaching out to sue Epic. And so I expect, if anything, we're going to see an upward trend in the healthcare space. So what happened between 2008 and now that has resulted in all of this increase in litigation? Well, a few things, right? And these slides don't capture even all of it. Right, one is the graph on the left is how many people are applying for a job online, and the answer is a lot. Right, not a shock to anybody that if you had a job portal or job listing that was not accessible to blind or visually impaired job seekers, for a lot of businesses that's the only way you can find or apply for a job, that those folks would be excluded. Over on the right is the increase of retail done online. Right, if you're like me, in 2008, you know what? I probably bought an occasional book on Amazon.com, whereas today I buy a substantial portion of the stuff that I buy on Amazon.com. So really the importance of the internet to people's lives changed dramatically. Let me make one more aside here. Right, all the examples I give, I don't mean to like pick on anyone or single anybody out, because truly, I mentioned Epic before. It could have been McKesson or GE or any one of a number of dozens of other providers. In most cases, businesses, unless they've made a really deliberate effort, are going to have a non-accessible tool. And so that would be my comment to you as well. Unless you have made a very deliberate and specific effort to code and program your websites and apps to be accessible for disabled users, it probably isn't. This is one of those things where more is less. Over the past decade or so, as technology has become more flashy and kind of more fun and exciting and vibrant user experience for most users or for sighted users, you've got maybe a video in the upper right-hand screen and a banner scrolling along the bottom screen and some other things happening. That's very difficult for accessible technology to read or kind of communicate to the disabled user. Whereas the old-fashioned, right, rewind again 10 or 15 years ago, and most websites were just, it was text on a page, right? And the technology behind screen reader technology, which is what visually impaired people use to access the internet, it's not brand new technology. It's technology that's been around for a while. So the website that was simple and straightforward from a decade or 15 years ago, as people sort of added more sizzle and pizzazz to it, it became less usable in most cases for the disabled user. I should also mention here that, of not picking on anyone, so my first slide had the lawsuit against Target. I was not involved in that litigation. I have no idea what Target's website was like at that time the case settled. But what I will tell you is because Target got the first national attention, that my understanding is that Target's website now is extremely useful and extremely friendly to disabled and blind users because they've been under so much scrutiny. And so I realize it's a different industry than the folks here, but if you're looking for an example of an accessible or a well-done site, or if you want to see some policies that they've posted, like an accessibility policy or an accessibility statement, one of my comments here is Target can be a great place to look and get some samples. That'll be tip number one. What else happened? So we've got an increasing number of folks looking to the internet for healthcare information. I pulled this from the Pew Internet and American Life Project. As an aside here, right? If you're heading to a cocktail event or a dinner party and you want a couple of interesting tidbits about the world, let me highly recommend the Pew Internet and American Life Project. They've got some great, I think, pretty high-quality statistical information. What else is happening? So this issue is being driven on the litigation front primarily by visually impaired, blind, or hearing impaired individuals. But the thing that's kind of is the giant thing that you haven't seen behind the scenes is the U.S. population is growing older. As folks grow older, right, my mom uses Facebook and uses the internet for certain things, and perhaps as she becomes less dexterous as operating a small screen, or when her vision begins to deteriorate, she's not going to just want to walk away from using these tools that have become so integral to her life, right? She'll be committed to those. And so there will be a business case on top of a legal case for accessibility and better user experience, primarily driven by like I said, the aging population. So what do we know about disabilities? Again, I'm just going to cover some highlights here. That keep in mind is we've got physical disability, sight, hearing, auditory, and cognitive. And it's a sizable chunk of our population. And the thing that I like to remember as well is that it's the third bullet point. People move in and out of disabled status, right? I feel like just on the elevator this morning, I saw one of my colleagues going up with a boot on their foot. That person is temporarily disabled, right, due to their foot injury. The other thing that I'll mention, I guess that's all I'll mention on that slide. So assistive technologies. These are what some of the technologies that disabled folks use to access the internet or to access apps. So again, point number one here is those folks use the internet and apps just the same as you and me. They just need additional tools in order to do so successfully. So we have in the top left, right, that's a kind of a Braille tool. We have in the bottom center JAWS, the shark. That's what we'll probably talk about most. That's the most well-known screen reading software. It tends to read from left to right and top to bottom, just the way that English print is read. So this is a legal presentation. Let's talk about what does the law actually require. I like to go back to basic and primary sources here because sometimes there's a lot of chatter from secondary or people heard something at a tech conference. But let's go to the foundations here. What does the law actually require? There's a couple of different anti-discrimination laws that will come into play, but far and away the one that has the most litigation is the Americans with Disabilities Act, Title III. You've probably heard of Title I is the no employment discrimination against disabled people, and we'll talk about that a little bit, but where actually most of the litigation has come from is Title III, which is prohibits discrimination from public accommodations. We'll talk about the definition of a public accommodation in a moment. But here, I'm actually going to read, right? What does the law say? And here, I'm quoting the law itself. No individual shall be discriminated against, and I circled that, right? What does that mean to discriminate? On the basis of disability, in the full and equal enjoyment of the goods, services, facilities, privileges, advantages, or accommodations of any, so let's circle the word place of public accommodation by any owner or person who owns or leases such a place of public accommodation. So what is a public accommodation? For the folks who are registered for this webinar, and I saw most of your business connections, it's almost all of your businesses, right? So here it's a hospital, a government office, almost any place that is open to the public. It includes, one more, right? So here's a portion of the definition, again from the statute itself, and that includes, right at the bottom half, a pharmacy, an insurance office, a professional office of a healthcare provider, hospital, and then here's the catch-all, or other service establishment. So that's really going to be most businesses that are on this call. What does discrimination mean? Again, the statute gives us some insight into what discrimination is. Right? So, and here I'm quoting from the statute. Discrimination includes a failure to make a reasonable modification in policies, practices, or procedures to make a good, service, or item available unless the modification would fundamentally alter the nature of the goods, services, or privileges. So what's a reasonable modification? This is how we start to see the complaints in the lawsuits, right? The plaintiff will say that you have a lawsuit, or that you have a website, or you have an app, but you did not modify your code, or you didn't take time to change the code so that it would be accessible with my screen reader technology or other assistive technology. more of the definition of what is discrimination from the statute itself, right? Failure to take steps, like changing your programming, necessary to ensure that no individual with a disability is excluded, denied service, or otherwise treated differently because of the absence of an auxiliary aid or service, unless it would fundamentally alter the nature of the good, service, facility, privilege, advantage, or accommodation being offered, or would result in an undue burden. So again, it just goes to this whole thing that what the plaintiff will claim, it's the same old law. No new law was passed leading to this uptick in litigation. No new regulations were issued, but rather it was some plaintiffs who were tired of waiting, saying this law by itself, what we see here, is enough to sue on, even though the law itself never was passed before the internet existed in 1990, and it says nothing point blank about what you have to do for websites. Let me talk for a moment about undue burden. So this is where, right, the cost would be so excessive or disruptive that that a business shouldn't be forced to make the change. This has been argued in a number of cases. I'll mention a couple of them later on. As of right now, right, April 2019, I'm not aware of any case successfully arguing the undue burden defense. There is a case, probably the most well-known case arguing this was Winn-Dixie. Winn-Dixie is, for those of you who don't know, is a grocery store and pharmacy chain in mainly the southern parts of the U.S., and they had a newerish website that a plaintiff claimed was not accessible. One of the defenses Winn-Dixie argued was that it would be too expensive to make the fix. The experts testified of a cost to make the fix between $37,000 and $250,000. That seems like a right ballpark for a fairly robust website. I've seen them go a little bit higher. I've seen them go a little bit lower in terms of costs for my clients. And what the court said in that case is that is not an undue burden. Winn-Dixie, you're a multi-billion-dollar organization, and you just got a new website a year or two ago that you paid a couple $1 million for. Therefore, at least in that context, no undue burden. And as I say, I don't believe I've seen undue burden argued successfully in this context. What other laws besides Title III of the ADA can be argued in cases like this? Almost every state has a state civil rights statute that significantly mirrors the Americans with Disabilities Act and prohibits discrimination on the basis of disability. Here's just an example from California's Unrest Civil Rights Act. But again, I'm not going to read this. It just prohibits discrimination on the basis of disability among other categories. How else can we get to the situation of the website and the need for accessibility? Is under the Rehabilitation Act. So Section 504 of the Rehabilitation Act applies to any entity that receives federal government funding. So most commonly, right, that's a hospital, it's a school, it's a university. So it could be a wide range of organizations. And what that law says, right, is no otherwise qualified individual with a disability shall be excluded from the participation in or be subjected to discrimination under any program or activity receiving federal financial assistance. So that, again, is a second law that can get us to the same result. I also mentioned at the bottom Section 508 of the Rehabilitation Act. That only applies to the federal government itself. So if you were, the Environmental Protection Agency and your website is EPA.gov, you actually, in that case, have some very specific requirements. They are the most clear requirements in terms of the standard that you have to meet for accessibility. There, under Section 508, as further amended, it specifically calls out a certain set of guidelines, the WCAG. That's WCAG guidelines. They're in a further slide, so you don't need to necessarily write that down. We'll talk about them later on. But unfortunately, other laws don't explicitly call out those guidelines, but a number of cases do. All right. What other laws create obligations for healthcare or healthcare-related entities? Section 1557 of the Affordable Care Act, and there are many folks on this phone call and in my office here that are more expert on Section 1557 because my focus here is really on technology and disability discrimination, so I'm not going to talk about other parts of Section 1557 of the Affordable Care Act. Here's some other pieces that it covers. So it's a broad law. I actually gave a webinar in the past with one of my colleagues, Marguerite Aman, who is much more knowledgeable in the area of in-clinic or in-hospital language or other communication assistance. So that's what we're not going to talk about, are those things. Call Marguerite or whoever you work with on those issues. We've seen very little litigation. I'm going to go forward to, I'll come back to the previous slide. Under Section 1557, I've seen very little litigation. Like I say, almost all the lawsuits explicitly referenced the ADA Title III, possibly state law, occasionally Section 504 of the Rehabilitation Act as the basis for their claims. I've almost never seen Section 1557, but I have heard some stories here and there of plaintiff attorneys sending out demand letters referencing Section 1557. And this is from about 2 or 3 years ago. There was an attorney down in Texas who was actually, I think, gotten some disciplinary trouble for just cookie-cutter, non-foundational demand letters. But he wrote out to, I think, hundreds of healthcare organizations. Since your website does not comply with federal law, and there he was referencing the Affordable Care Act, you must immediately self-report to the Department of Health and Human Services and forfeit any federal funds received from Medicaid or Medicare until you have completed recertification. All right, so I'm not the sky is falling attorney. I don't want to be that person. So let me just say, to my knowledge, that claim has not been asserted, certainly not successfully in any court anywhere, but you might see it, and that's just one more piece of the puzzle. All right. One other way that accessibility or action to improve the accessibility of your website might be required is by contract. And so, for example, you might, this is actually where you might put this on your vendors to you, or if you're a healthcare vendor to a customer, you might see this, right? The vendor will comply with all applicable laws and regulations in providing the services and deliverables. I'm actually seeing more and more specific reps and warranties in technology-related contracts in the financial space and in the healthcare space that says, hey, website developer or app developer or whoever is providing certain technology tools, what you provide, you represent and warrant, must comply with the ADA, must comply with the Rehabilitation Act, and comply with this standard, the WCAG, the Web Content Accessibility Guidelines, Section 2.0, or actually now it's probably Section 2.1, Standard AA. One of my very, very last slides in your whole packet that we'll get to has some suggested language that, again, if you're a healthcare entity, you might want to add that to your standard procurement process to kind of like your template vendor services agreement, because this is a way for you to require that folks who are building stuff for you build stuff for you that will not get you sued. All right, we covered that slide. So we've now covered some foundations of the law. What does a typical complaint look like? Again, I'm not picking on Heartbeat Health. I could have picked any one of 100 other complaints that have been filed in the past week or two or month or two. This one happens just to be from February of 2019. So, but it has many of the classic elements that you'll see again and again. So it was filed in New York. Again, New York is the most common place to see these lawsuits filed. There's a number of active plaintiffs and active firms in New York. Aretha Crossan is the named plaintiff. I looked it up just the other day. I feel like in the past 12 months, she's been the named plaintiff in, was it around 40 of these lawsuits? I may not be right on the precise number, but that's kind of the ballpark. And she's visually impaired or blind, according to the complaint. Again, that's the most typical. I bet that visual impairment accounts for about 90% of these cases. Hearing impairment is probably 9%, and then 1% might be other. But visually impaired is the dominant category. You see at the bottom, it says complaint class action. Most of these are styled as class action complaints. Now, very, very few of them end up being certified as a class action because that's a pretty labor-intensive and expensive process. So most cases settle long before then. And then Heartbeat Health, to my knowledge, they do some kind of heart testing and have some facilities in the New York area. So it's a blind plaintiff, health-related business. They have a website at whateverit is.com. The plaintiff then alleges that they tried to access or get information from the website using their screen reader tool. In many cases, this JAWS tool that would read the website aloud to the visually impaired person. But due to a list of specific barriers, the person was unable to successfully gather information from the website. Some classic examples of like what didn't work. I'll give two examples. One is what's called alt text. Alt text, that's ALT. Alt text is where someone describes or types in what is in a picture or a photograph, right? So if I've got a picture of a let's say a graph of the risk of cancer according to age, if you entered no alt text behind that, it might just say on JAWS, image file, no content, image file, no content, right? So not very helpful. Whereas if someone entered the alt text, you just code in kind of what I just said, right? Graph showing increase in risk of cancer correlating with age or something like that. Or maybe, right, photograph of doctor and patient or whatever the description is. So that's alt text. And leaving that out kind of leaves the blind person hanging. Actually, I'll give one more example. On a number of websites, there will be what looks to you and me like like a button. It might be like a login button or it's like a bigger button you'd click on to like log in or do whatever you're going to do. Well, sometimes those are image files, right? So you can see that if the screen reader says image file, no content, then the visually impaired user won't ever be able to find the login button. So that's one example. Another example is what we call the ability to navigate either by tab or arrows, because if you're visually impaired, you don't use a mouse because you can't see where the little cursor piece is on the page. So the way that most visually impaired people navigate is through arrows or the tab function. So, and actually, this is one way that you can test your website yourself, or your IT team could, is if there's a button or a function or a link on your website and you can't tab or arrow to it, then that's not accessible, kind of by definition. So in the complaint, then the plaintiff will name the list of things that they had trouble with on the website. They'll list the specific barriers. They will list the damages or the amount in controversy. In this case, they said it was greater than $5 million was the request. They'll name the specific laws that they believe are violated by the non-accessibility of the website. And in this example, which is typical, it was the Americans with Disabilities Act Title III. It was the New York State Civil Rights Law. And those were the two laws they claim were violated. The relief sought is monetary damages, and then an injunction or court order requiring the website operator to improve the accessibility of the website. And by the way, this is a public document that I just mentioned. If you want a copy of that, feel free to contact or email me, and I can send that out so you can see an example. All right, let's see a sampling of key cases. We've now seen the law, what plaintiffs tend to allege. What are courts actually saying? Since we don't have regs to interpret this area, all we have are cases. I mentioned before kind of the early case in California. The National Federation of the Blind alleged that the website Target.com was not accessible to blind users using a screen reader technology, and therefore that violated the Americans with Disabilities Act Title III and state law. Target moved for summary judgment, claiming in part that a website is not a, quote, place of public accommodation. And in response to that, here's what the court held on the motion to dismiss. It said that to the extent that there is a nexus, and let's circle the word nexus on my bullet point there, to the extent that there's a nexus to the goods and services offered in a particular store or location, then the court will not dismiss the claims. But if there were some parts of the website that were totally unrelated to the physical location, then those claims would be dismissed. So again, I think for most of the folks on this phone call, that's going to still mean that your website is covered. Because if your website describes the location of your facility or the hours of your facility or the providers who work at your facility or the services or treatments offered at your facility, then according to the Target case, the ADA does apply to your website. As I mentioned before, that case settled after this motion was brought, and now Target has an impressive website. Let's look at another key case. So back in 2015, a plaintiff brought, Cullen was the plaintiff, brought a lawsuit against Netflix. And Netflix, right, is the quintessential online-only business. So there is no physical location, at least not where the public interfaces with Netflix. And here the court ruled, I'm just going to read this, we have previously interpreted the statutory term, quote, place of public accommodation to require some connection between the goods or service complained of and the actual physical space. and they give a citation. Because Netflix services are not connected to any actual physical place, Netflix is not subject to the ADA. So now, those of you who have an online-only business, so if your business is maybe just a health information, maybe you are a insurance or other tool or provider that does not have any physical stores or storefronts that are open to the public, you now have a defense if you get sued. And that defense is that the ADA and the ADA only applies to physical places. However, this defense is going to depend upon where you are and where the lawsuit is brought. Because I give a contrast, the National Association of the Deaf versus Netflix, the same thing, where that court in Massachusetts in 2012 reached the exact opposite result. Frustrating, yes, I agree. Another case in New Hampshire where Blue Apron, which is an online grocery delivery service, they were sued, and the court again held that online only, the ADA still applies. So this is one of those things where, again, if you're an online only business, I don't think that you can just blow off this issue because the defense depends upon where you get sued. Now, if you get sued in California, which is in the Ninth Circuit, you might have a pretty good defense. But you might get sued the next week by a different plaintiff in Massachusetts or New Hampshire or any one of a number of other places, and there that defense won't work. This case is from 2019, Robles versus Domino's Pizza. And this case is significant because it actually took away a defense. And again, I'm a defense-only lawyer in this space, and so we had potentially a really powerful defense based upon the trial court initial decision in Domino's Pizza. So again, standard complaint, right? We have, I believe it was a visually impaired plaintiff who claims that they could not use the website, and that violated the Americans with Disabilities Act, Title III, and possibly some other laws. Among Domino's defense was that because what it means to be accessible, like what the standard is, what do I have to do, is so unclear, and because the Department of Justice has for years and years delayed and failed to issue regulations that would give anybody a clear path to compliance, that is a violation of the 14th Amendment to the Constitution, which requires due process. One of the kind of pieces of the 14th Amendment is the concept that a business or individual, laws need to be sufficiently clear that an individual who wants to comply with them knows with sufficient clarity what they either have to do or what they can't do, right? So if the speed limit is 55, you can't drive over 55. And in this case, right, it's like, well, you can't discriminate in your website against the disabled. Well, what does that mean? And I share the frustration of these defendants and website operators that the standard is not entirely clear. So that defense was successful at the trial court level, but in 2019 that defense was taken away. So the Ninth Circuit Court held that even though there aren't regs, and even though there might be some fuzziness, or as they called it, flexibility, to how one might create an accessible website, it was not a violation of due process, and the lawsuit was allowed to go forward. We think that this case actually might be appealed to the Supreme Court, or maybe it has been in the past couple of days or weeks, to be continued. Gill versus Winn-Dixie, I mentioned this earlier on, and this was one of the first, it was actually the second major case that I'm aware of that went to a full-blown trial or a final decision on the merits. That case, the first case was in California, Colorado Bag and Baggage, I believe, but you couldn't even tell from the court pleadings or filings whether the defendant tried to defend in that case. In this case, Gill versus Winn-Dixie, Winn-Dixie did defend in a robust way, and they were unsuccessful. They lost at trial, and one of the key takeaways for the folks listening here is that under that court decision, there were multiple kind of, I'll say, parts or pieces to the website. Part of those were controlled directly by Winn-Dixie. So, for example, the store locations, store hours, maybe what was on special that week at a particular location. That was controlled directly by Winn-Dixie. But the website also had a loyalty program. You can kind of see there's a little card with a checkbox in the middle saying Winn-Dixie customer reward card. There was also some level of like online shopping. And those pieces, like the checkout payment cart, was not controlled by Winn-Dixie. That was a third-party service that Winn-Dixie hired. And the loyalty program was also operated by a third party. One of the holdings of the Winn-Dixie case is that Winn-Dixie was responsible even for those pieces of its website that were operated by a third party, because Winn-Dixie got to control and pick the third party. So that's, again, it goes back to my earlier tip or recommendation that next time you're getting a website update or a refresh, or you're buying a new piece of technology, you really want to put in that contract that it will be accessible, comply with the ADA, and that vendor will defend and indemnify you, because if they don't, I'll say in that case, Winn-Dixie could have shifted their risk. By way of contrast, my biggest case of 2 years ago was not actually a blind plaintiff suing a website owner. What it was a dispute between a large financial institution and their website developer that had built their website for them. That financial institution had a great contract for them, which said that all work product and deliverables will comply with all applicable laws and regulations, and for any allegation even vaguely related to a violation of law of a deliverable, the developer will indemnify and defend on the lawsuit, and they'll fix the problem at no cost. Well, the lawsuit was settled fairly inexpensively and quickly because, again, most of these, for the vast majority of these cases, they settle quickly because settling is so much less expensive than defending, even if you think that the case is of dubious merit. So in that case with the financial institution, it was settled economically, but the large financial institution got about $500,000 of free upgrades to its website provided by the website developer because they had a great contract. All right, a few more defenses. So one is no standing, and there are a couple cases where this has actually been successful, mainly in Virginia and West Virginia. They've typically involved banks and financial institutions, like a credit union. And the principle is when a plaintiff brings a lawsuit and they weren't even eligible to be a customer, and so I suppose you might say, right, if you had a healthcare organization that was only for veterans or only for women, and a male plaintiff sued you, the argument would be that person does not have standing because they are not a viable or eligible customer of your business. So that has been successful in some cases. In some cases, actually, that was even successful where it was just a significant distance between this particular bank and where the plaintiff was located. And what the court said is, you know what, there are like 100 different banks that are closer to where you live. I don't really believe that you're that anyone's going to really bank at a place 300 miles away. Now, I don't know that would carry the day because as we move to more and more mobile and online banking, again, not to undermine a defense because I'm a defense-only person, but I would just say this. It might be a defense that you can argue, but I wouldn't bet the farm on that defense in a particular case. The other, and this I think defense also has some promising elements to it, is that the claim is moot because the defendant has either begun a fix of the problem, or in some cases, it is even by the time you get to court, has completed the fix. So one thing to consider if you ever encounter a lawsuit in this space is, can you start work on the fix, or perhaps hire a third party where you even have like a statement of work. Here are all the things we're going to do that we're going to fix. That could be a viable defense. Again, in some cases it is, but as you see from the bottom citation in this Haynes versus Hooters case from the 11th Circuit, the mootness defense because a fix had been begun or there's a previous similar lawsuit that was settled and a fix begun under the previous lawsuit was not successful. Bottom line on litigation, again, I just share with you the frustration that courts are not speaking in one voice or with clarity. Here's the bottom line on litigation. 90+% of the cases settle in between 2 days and 6 months because it is so much more economical. If you have, and listen, I would love to defend to the nines a business that had what I thought was a strong winning defense in the jurisdiction in which we're located. And we have in some cases mounted a defense, and in some cases we have actually gotten plaintiffs to back down. But here's the other part is just looking out for businesses is I've seen some cases where businesses have defended and they're like in a Massachusetts or a New Hampshire or some other jurisdiction where that defense has been tried in that specific place and has lost. And I really wonder what's going on there. Like, why are you defending when that's just like adding legal cost before you lose? So I would just say find a lawyer who knows the ins and outs of this particular issue before you go wasting money, because that's a bad way to go about it. All right, what else do I say? Most but not all cases survive a motion for summary judgment. Legal arguments continue to evolve. I have learned so much from my clients over the past couple of years on this issue since I began defending. And I'll just say that there are new arguments that could happen anytime. So put on your creative thinking hat if you end up defending. All right. Just doing a time check here. Yep, I see where we are. All right, so what else has been happening? This is a big change. Is that everything we've talked about so far has been applicable to customers or end users of your business and not employees. We have started now to see an increase in cases brought under Title I of the ADA, which is the employment piece, or again, equivalent state laws. And here's just an example, right, that this particular school was the defendant in this case, but the same law would apply in the same way to a healthcare organization. So you had a blind employee who was a counselor at the school, and she had to log in some of her visits with the patients, or the students that she was seeing. She had been doing that successfully under the old tool, whatever the old computer tool was. But again, there was a quote, newer upgrade to the new tool. All of a sudden, her screen reader software would not work with the new supposedly upgraded tool. There has to be an interactive process under Title I, the employment piece. So the employee reached out to the school and said, hey, what can you do for me? We don't have a ton of detail about that, but there was at least some level of back and forth, but it was not successful. It broke down. Ultimately, this settled for more money, $250,000. That's one of the few public settlements. This is significant because although bringing a Title I employment lawsuit is a little bit more cumbersome and burdensome on the plaintiff, the amount of damages at issue in settlements are also a big order of magnitude higher. So for you now wearing your employment hat, you need to think about what tools are my employees potentially using, what computer tools are they accessible. I suppose the good news here, and there's a lot of stuff happening behind the scenes, right? Microsoft, Google, a bunch of big companies that offer tools used by workers have been investing tens of millions, hundreds of millions of dollars, a ton of money in making their tools accessible. But as you go into more niche tools, you're going to find that they may not be. All right, back on Epic, right? This is a headline from this year. Epic electronic health record software isn't accessible for blind hospital employee, a suit claims. What this lawsuit claimed, and actually there were a couple of them that were similarly related, but one of them referenced an employee who was a dispatcher. So I guess once a hospital room had been used but the patient was gone, there would be some kind of a message, electronic message sent to the dispatcher, who was this blind individual. And then he would send out an electronic message by his computer telling, for example, the cleaning person to go clean room 203 because it's empty now. This person had the job for over a decade and was able to use the old software successfully to do this dispatching or scheduling. Once the hospital upgraded to Epic, though, his screen reader would not interact, and that was the basis for his employment lawsuit. This one was settled, I believe. Do I have here a slide? Yes, sorry, it's not a slide, but I'm going to read to you a portion of what the complaint said. So again, this isn't the court decision, this is the complaint. Well, Epic has taken steps to make patient-facing portions of its electronic health record software accessible with screen reading software so that blind patients are able to access their health information. Epic has not made the clinical or administration-facing portions of its software accessible to blind healthcare workers. Because blind individuals cannot use Epic software or the clinical or administrative side, they are effectively barred from employment at hospitals and facilities that use Epic software. This case is still pending, look for an article on our website or an update. But if it goes the same way that the Miami-Dade case went, there could be a substantial issue. I'll just mention this, the Internet of Things. As we get more and more smart machines, we are now starting to see litigation in this space. So this is an example of where the machine at issue was, again, not in a healthcare organization, but it might as well have been. It was a checkout scanner at Walmart, and the National Federation of the Blind, again, they can be a preview of things to come, sued, saying that the scanner displayed the prices and other product information on the screen, but didn't do an audio signal. Or you couldn't hear what was going on for the self-checkout. Again, Walmart is defending that case, so to be continued. So what are you actually going to do, right? So we've talked about the conundrum and that there isn't fantastic government fantastic government or court guidance, although we have some. We know that the ADA probably applies, and we know that you probably need to do something to help covered individuals access or use your website. So when I have a new client, I will use an automated electronic scanning tool, and there's a number of them out there. There's one called Wave, W-A-V-E. It's free, at least the basic version is free, and it's out there. And that tool is just fine, but it only captures, in my opinion, a very narrow piece of all the possible. I think there are both false positives and false negatives. And so here, right, this is from the U.S. government. What do they say about scanning tools? No automated evaluation tool can tell you if your site is accessible or even compliant. Manual testing is always necessary. So in the same way as no tool could tell you, what is or is not harassment or sex or gender discrimination, in the same way, right, whether a site is accessible is a human experience decision or experience, right? Could a hearing impaired or visually impaired person go to your website or go to your app or go to your piece of software, and could they do the functions that anyone else is doing on that website, app, or tool? And if the answer is no, then it may well not be accessible. So that there may be some level of manual testing to determine whether or not you are accessible and compliant. Here's just one more example of the scanning tools, which again, I think they can be somewhat helpful in helping you problem solve, but they're not the end of the day. So I just ran this on the National Federation of the Blind website. Let me assure you, the National Federation of the Blind's website is nfb.org, works really well for blind people. Okay, let's just take that as a given, that their home-based website works well for the blind. And yet running a scanning tool, it tells me on the left-hand side how many errors? 11 errors. So those are either false positives or not real errors, and it just goes to how you can't hang your hat entirely on a scanning tool. So what should I tell my IT department? How do you actually work with them to reduce your risk? Well, there is a standard. It's called the Web Content Accessibility Guidelines, version 2.0, but actually now there's a version 2.1, so let's circle at the very bottom bullet point, 2.1. There's different versions. There's A, AA, and AAA. I'm not going to go into the details here, but I'll just say AA, WCAG 2.0 or 2.1 AA is what the Department of Justice points to when they say what is accessible, what a number of courts have pointed to. Now, people also kind of have this little caveat. It might not be the only way. There might be other ways, and the internet changes fast, so maybe there's something else, but this would be one way to be accessible. So in light of the fuzziness and confusion, if you're looking for something that's pretty concrete, I would say look at the WCAG guidelines. So here's a hyperlink on this slide to the WCAG guidelines, right? So www.w3.org, and there are the guidelines, right? You could show these to your IT staff, and they can begin to take action on these. Now, again, testing to make sure that they did the job right is hard to do. You might want to consider getting an outside tester to do it because it's really hard to test yourself. But that's at least what you could point to your own internal or external staff. What are some of the things these guidelines require? Things that we've already talked about, right? Alt text or text alternatives behind images, captions for videos for the hearing impaired, keyboard navigation, right? That's the arrows or tab and not the mouse. Consistent design, color contrast. One of the things with color contrast is that I think it's 1 out of 9 or 1 out of 10 men have some level of color blindness. So if you're picking the wrong color contrasts for important information, you are leaving out part of your audience. So here's what you can do to try to reduce your risk. Number one, audit or review and improve your website. That's really the most central element, is that if you are trying to not be sued or not get a demand letter, that actually having your IT staff take action, or your vendors, to improve the quality or accessibility of your website, that number one is far and away the winner. Okay. Other pieces of this puzzle, my second bullet point, procurement and vendor selection process, right? The analogy that some folks give is when you is to like a house or a building, that if you're building a new building and you want to make the hallways wide enough for a wheelchair, when you design your building, designing wide hallways, that's pretty straightforward and easy to do. Whereas once you have a built building and now you're going to like move a wall to make it wider, that's super expensive. So again, for those of you, even if you have not been sued, I would say try to build into your vendor selection process for a new website, a new app, or potentially even other tools like your EHR system like Epic, right? Building in a representation and warranty and indemnification that it will be accessible, because so much cheaper and easier for you to solve it before there really is a problem. Or assess the remediation and recheck, post an accessibility statement. So work with your legal counsel on this, but an accessibility statement, usually it appears on a website down at the bottom where you've got like the terms of use and maybe a privacy policy or a privacy statement. You also have an accessibility statement, the central element of which is that if people have trouble, there's a phone number or email address that they can contact to perhaps get some alternative form of communication. I'm not going to, again, read all of these points here because you have them in the slides. Yeah, I'm going to keep going here because these all kind of speak for themselves. Monitor, do some training, appoint a person as an accessibility coordinator. Actually following through on these things, especially for larger or mid-sized organizations, is hard, and it's easy to kind of forget, like, oh, we just have a website, our vendor said it was accessible, but then guess what? 6 months later, as you add new photos or new text, it's no longer accessible. If you appoint someone, and it doesn't have to be their only job, it does not have to be a new hire, maybe the person's in IT, maybe the person's in legal, maybe the person's in compliance or HR, but give someone as part of their job title accessibility coordinator so that they, maybe on an annual basis, give a report to legal or to your board or to your some leadership level. And they also remind people, for example, in procurement, to make sure that you're procuring accessible technology or shifting risk. All right, here's my example of a pro customer warranty. And again, is this right for you? I don't know, but it was a pretty good fit for some of my clients, and so I offer it to you for your consideration. All right, and we're getting close. Let me just see where I am. Actually, yeah, questions. So, right, no questions so far from the audience. That is fine. My colleague David stopped by and has a couple of post-it notes. Should I read those, or do you want to mention those?
I can just quickly say, first, thanks, Steve, because this was awesome.
My pleasure.
People often wonder, hey, where are the slides from this? So in the email you got with the registration material, there is a copy of the slides. So you can see them there. And so you do have them, in fact, right now. If you missed part of this, or if you want to share it with a friend, by Monday, this will be up on our website, and it and all of our past webinars are there, and they're free. So you can listen to Steve over and over again. But if you've got someone in your organization that you think would benefit from it, you can send it to them. I do see a question is coming in, so Steve will read that. And I guess the only other announcement is, before Steve handles the question, is don't forget May 15th, we'll be talking about marijuana, or I won't because I don't know much about it, but Kevin Rich will be talking about everything medical providers need to know about marijuana. And Steve, if you want to handle the question.
So this is a great question. Are there vendors that can test and certify WCAG compliance? Any recommendations to what to look for? So really great question. And here's my answer is yes, there are a few organizations. I'm not going to actually name any here. But I'll say, here's what you want. You want an organization that actually has at least some level of live user testing, and I'd say preferably including a blind person on staff. One of the things I've found over the past couple of years is that almost every web development firm or app development firm in town has added on their bullet point of 27 different services they offer, they've added bullet point number 28, accessibility. And that means that they sent one of their interns out to listen to this lecture, and now they added the bullet point to their thing. But they really aren't qualified or well qualified. So I would say do your diligence on your vendor. And if they really they should be focused on this and have probably some level of live user testing. Those are the tips that I would give. And then I'll reach out to the person who asked this specific question. There you go.
Thank you so much, Steve. We really do appreciate your wisdom. And thanks for joining us. If you have questions for Steve, you know how to email him. And you always should feel free to reach out to any of us here at Frederickson. And thanks. Have a great day. I hope you can see some of the Lyriad meteors tonight.
Thanks, David. I'll try to check those out.
Okay. Bye.
Bye.